You see, when last year there was a similar petition for the removal of the special prosecutor, the NDC refused the idea that it was merely a conveyor belt. They said no. There was a need for some discretion to be exercised by the president. That why did the president send it swiftly? I remember being interviewed in one TV station that the president sent it swiftly to that of the Chief Justice. And I said, how can you call something swiftly? What the president have done in the last day, this cannot be swiftly. But we're told the president doesn't have discretion. I still believe president retains some discretion. That even though it has, discretion is not stated, but we can infer. If you send a petition that remove the Chief Justice because he had food for breakfast instead of watching, and should the president just send it to the president? I'm using these ridiculous examples to demonstrate that at all points, people who occupy public institutions will still need to exercise what they call it discretion. Because as Aristotle and St. Thomas Aquinas tell us, we are rational beings. And at all times, our reasoning must always agree with our nature. And our nature and our reasoning always tell us we must always apply discretion so that we don't waste everybody's time. So if the speaker, if the president received thousands petitions to remove the Chief Justice, each time he received it, then he passed it to the Council of State.
Yes, I agree. I mean, I think it's practically absurd.
Yes,
it's practically
ridiculous.
absurd. Yeah, it's absurd.
So the NDC is now running from, if it's not a conveyor belt, it's a conveyor belt. This is what we talk about, principle of consistency. I mean, it doesn't just make sense. So let's come to whether there is a motive behind it. I believe so. I believe this current NDC government is a threat to our judiciary. And every right-thinking Ghanaian must rise up. Why do I think so? Especially the Chief Justice. They already have a bone to pick with her. You remember recently, just about 4 or 5 months ago, when the Speaker of Parliament tried to illegally grab power from the High Court under Article 99 by removing those 3 or 4 members of Parliament. The judiciary had opportunity to first make pronouncements. And when they asked them, we are going to look at the substantive issue later. But in the meantime, let's preserve the status quo. The Speaker of Parliament, who is an acting member of the NDC, he had a press conference, or he was in a gathering. I heard him, not that somebody said it. I heard him say, the judiciary at the highest level, and the Speaker was in bed, and they were sinning against the Constitution. The Speaker of Parliament, the current Speaker of Parliament said it. And when the Speaker of Parliament lawyer went to court in an attempt to defend the Speaker's position, there was a lot of hot exchanges to the point that the Speaker of Parliament was so, the Chief Justice was so frustrated that she even asked, what are you doing?
Okay.
Because everywhere the judicial courtesy, you want to...
Yeah, just a second. Just a second. So I'll let you allow... Oh, please, Annie, bring this thing back in. I beg you. The Article 146, the one that you showed us earlier, yes. Now, the judicial courtesies, I'd like you to come back to that. But, so, Annie's decision to bring this thing back then sort of draws my attention to something which I thought was quite interesting. So look at Article 146, removal of justices of Supreme Courts.
Yes.
Oh, sorry, Superior Court and chairmen of regional tribunals. Yes. Okay. Now it says a justice of the Superior Court or a chairman of the regional tribunal shall not be removed from office except for stated misbehavior, right?
Yes.
Or incompetence, or on grounds of inability to perform the functions of the office arising from infirmity or body of mind.
Yeah.
Now, a justice of the Superior Court or Judiciary or a chairman of the regional tribunal may only be removed in accordance with the procedure specified in this article. 3, if the president receives a petition, now this is what is interesting.
Yes.
If the president receives a petition for the removal of justice of a Superior Court other than the Chief Justice, or for the removal of the chairman of a regional tribunal, he shall, what's that?
Yes.
He shall, not me.
I'll come to that.
He shall refer the petition to the Chief Justice, who shall also determine.
Okay.
And you lawyers have said it time and again. That shall means you don't have any options.
You have options. No.
It's
mandatory.
Please, if some...
it's
So apparently
Yes.
it is clear.
It's an operating... No, okay, let me come.
Please come in.
I will cross-check something and get back to you.
Okay.
We have a Supreme Court decision in this country that tells you sometimes shall can be read as may.
Really?
Yes.
If you want,
I've forgotten it. I mean, you can help me.
Yes.
I've always had issue with that aspect, that sometimes shall can be read as may. And as I've already said, we have agreed this, that if the president were to receive 1,000 petitions a day, seeking for the removal of the Chief Justice.
No, you know what I read this to you?
Yes.
I read this to you because you remember your preliminary comment?
Yes.
Your preliminary comment was that, look,
Yes.
you believe that the president has discretion.
I mean, because we are rational beings, in a sense that if the petition were to say that the Chief Justice had banku for supper yesterday instead of fufu, is that a ground to pass it on to the Council
So we
of
can
State?
look at the consequences of the use of shall.
Yes.
Rather than now trying to interpret
So what we
shall
are saying is
could
that
possibly
even
mean,
though it might not be
depending on the
stated,
context.
but I've also provided to you that there's authority in this country that
says shall
where
can
the
be made.
Supreme Court says that sometimes shall can be read as what? May.
Anyway.
I
am a mere mortal.
You see
so
that?
I won't debate you on
it's
this.
my turn.
When it comes to law.
It's my turn.
Yeah, finish.
But so I was putting the suspicion that we have.
Okay.
I've already told you there was some exchanges in the Supreme Court, whereby a lawyer was openly exchanging with the members of the judiciary, and the Chief Justice.
Which lawyer is this?
listen, I was in court. I was part of that.
You know that.
Yes.
What he's talking about?
So let me count. So you will bear me out.
I was there. I was an active participant.
You will bear me out.
No. So
I
I'll
wasn't in
correct.
court.
I'll correct.
I wasn't in court.
Yeah. So you
To
didn't
the
see
point
what
that
happened.
it doesn't matter. But I saw with the telly.
Yeah.
I mean, sometimes when we sit home, we see better than what those of you inside there. This is why I don't go to events in Independence Square. When I sit home, I sit proper than you do. But I saw the Chief Justice expressing frustration.
Yes.
Don't you have respect for members of the bench anymore? Because this lawyer was directly exchanging. And as I said, there's a judicial courtesy. I'm training the English system, I'm training the Ghanaian system. The system everywhere, because this is Commonwealth country, we borrow them from there. Whenever your colleague is about to speak, not a judge, your colleague is about to speak, and the judge signals to your colleague, you ought to sit down. And here is the case, a judge is exchanging with a lawyer, and the lawyer is standing and refuses to sit. This was a frustration the Chief Justice expressed.
How is that related to the petition?
No, what I'm saying is that it was everywhere that the Chief Justice have taken sides.
Oh.
And this is how he's suspected.
Okay, based on that
TV,
interaction.
everywhere. The second where they said there was a misbehavior was the fact that the Chief Justice expressed, why is Parliament not sitting? Why is Parliament not sitting?
Do you have the petition?
Said that,
do you have the petition to say that these are the stated misbehavior?
No, what I'm saying that
you're conjecturing.
Yes, and we are allowed to. We are allowed to.
No, let us.
We are allowed to.
Not let's do something that is not part of.
When she said that,
listen, she
said that in reference to the point that the court has already made an order. Parliament should resume as normal. The status quo is preserved until the substantive matter is stated. And you can also know that the Afrobarometer report, the members of the NDC had polluted the minds of everybody about our judiciary to the extent that this reflected in the Afrobarometer report. But what I'm trying to say, be very careful the way you are running down the judiciary.
Okay.
And now you are hiding behind, you can't state the reason, you can't do this, you can't do this. And
but that is the law. That is the law.
I understand that. And that is why you are trying to abuse the law. You are trying to hide behind the law, to abuse it. But I would tell you, I would like to appeal to John Mahama. Perhaps he's more or less like a father, or maybe our age relationship is perhaps an elder brother. If you want to preserve your legacy, please concentrate and deliver your mandate. But if you are seen to be fiddling with this, our institution, you will not have legacy to be left. You only have 4 years. You can't come back again. And this 4 years, don't let people use you to pursue their enemies.
Now, if you say that NDC is a threat to the judiciary, I think that this statement is not in accord with what we have seen. How do you say we are a threat? What has the NDC
What
done?
you were saying
Consistently, if NDC only voice or vent their frustration when the judiciary was taking some stance and position, and even the NPP itself made it worse, because their communicator will tell you, if we have any issue with you, go to court. And once you go to court, what they have said
it's an expression of confidence.
Becomes an end. What comes to the end? It becomes unanimous. Everything was unanimous. Every time they had issue. So if I have a reservation, I have a reservation. Look, the law
say go to court.
You see, where the law? Listen, where the law?
Arms?
No, please. You had your turn. You had your turn, Ishaq. You had your turn.
Okay.
When the law, you see, the law is there. The law is a double-edged sword. It's in the hands of the person. He can use it for good and can use it for evil. And if you are using it for evil, and somebody thinks that the way you are crafting the judgment and others, I don't have that confidence that when I come, I will get the deserved justice I want. So I'm going to do my things in a way that I won't be able to come. Now, listen, when you say that, if you say that it's a threat to judiciary, I think that it's unfortunate for you to say that, right? When you were trying to, the perception people had, citizens had, that you were trying to use the judiciary to weaken the legislature. Even your own dean said it in public. No. He said that every time the legislature, any issue they run to the court, they are weakening the judiciary. And when somebody says that, no, I've also been given power under the Constitution, I must exercise it. And you say that's wrong. You see, when he comes and say exchange with the bench, it was disrespect. He was not there. I was part of that case. And I went with Sari Tajosori. When Tajosori was arguing, they were asking him questions and he was responding. And even what worsened the case was that at the time, Dami was questioning the legality of he being retained as a lawyer. When the speaker has appointed a lawyer, he says that it was public and you have to go to. And he was telling him that, look, even when we come, let's talk about, now you are talking about how I have been appointed, that the speaker does not have power to appoint me. And he was telling him that, look, parliamentary service had approved that he should be appointed. He had a letter, Dami had a letter, but he refused to make it available. And the man was just trying to say that this is how parliamentary service, you come and you say ethics, we were exchanging. So if the truth is not coming out, the lawyer should be quiet. He doesn't have right to say this is the position.
Okay.
That is what you are saying. So if please.
He's responding to me now.
Yeah, so I'm telling you that all that he said, listen, please, there's a procedure. There is a shall.
Okay.
Now, where you are asking the shall and the may, it's in the Interpretation Act.
Okay.
Are you getting it? The Interpretation Act says, but this is the Constitution, the highest law of this country.
You mean the court pronouncement was on the Interpretation Act?
Yes.
Okay.
Interpretation
I don't
Act.
remember. I'm going to reference it because
look
I
at the
remember
Interpretation Act.
How a judge can just change it.
The Interpretation Act. And the court has made it clear when it comes to the process. And
but
he
in
says
practical
that
terms, you don't agree that the president should have some, at least minimal discretion as to what to say.
You see,
otherwise, tomorrow we are going to flood him with
the framers,
and he shall send them.
But yes,
if this is why you are advocating,
that is what
people
you can. You see,
and we flood him with petition, and if he fails to do so, we'll take him to court.
Is
that what you want?
Listen, if you flood, he will send it. Once he send, the Chief Justice.
If you are listening, the president is a conveyor belt. Send whatever petition you want. He shall send it to the Council of State.
If it is frivolous, and the Chief Justice look at it and say this is frivolous, and it's thrown out, What is the problem?
So we
you have
to
followed the
do
process.
that. He has no discretion.
Go through the due process. Don't arrogate to yourself
whatever
what the
listening,
Constitution has not given
all
you.
he's saying is that there's something
I
defective
get
there.
it. So
And it lends to abuse. People will just abuse it.
Yes.
So that's what
the
they do.
point, yeah.
Even when the Constitution says that you can come as a citizen under Article 2:1.
Yes.
Anything you think, any law you think that is inconsistent with the Constitution,
They come to
everybody.
Constitution doesn't come to court.
Wait. Everybody you can come to court, and when the court you come,
Okay.
and they think that it is frivolous,
Okay.
you are thrown away.
No, that can't
Are
be
you getting
cost.
it?
Yeah.
When they are
Can't be
trying,
cost.
so if the president they bring it and the chief justice thinks that this is frivolous, it's a matter of throwing it away. And if you throw it
How
away,
do we deal with potential abuse?
no. So listen, the potential abuse, everything here. Look, the Ajay Trum case. It's just I don't want to
And let's move away
go.
from it.
No, the Ajay Trum case.
Yeah.
It says something very here. It says that the purpose approach, what he talks about,
Yeah.
require that the contents of the instant case, implicit words, be read into the Constitution to avert
Exactly.
manifest
They read words
absurdity.
into it.
Okay.
Thus, there was room for the unwritten in a written Constitution. The fact that the country had a written Constitution did not mean that only its letters might be interpreted. The court had responsibility for distilling the spirit of the Constitution from its underlying
Reading words into
philosophy,
it.
core values, basic structure, history, and nature of the country's legal and political
Okay.
systems.
All right.
So once interpreting that provision, they have put everything, and they said that even if it is not explicit in the Constitution, the court has the power
Exactly.
to put it in. That is
So I said
exactly
it's
what
not
they did.
explicit.
So if we are saying that, but the court says that is what they did.
Okay.
The
So
reading.
the reading. So where
So, but
where
the Muhammad
opportunity?
could read in
no,
discretion.
no. How could he
You see,
read the discretion?
Constitutions are
How can
open
he read
textual.
discretion? Please,
You see, let me
please,
come,
your
let me
students
come.
are watching you.
Yes.
We
They are
should
watching me. I'll refer
yes.
them to a book
No,
by
yes.
Jeremy
So please.
Woodrow, the law. The
Yes.
law.
Jeremy what?
Jeremy
No, no.
Woodrow.
This is
and
a
that's the
constitution.
Professor Hart. No, let me
Yeah,
come.
are you
I'm
getting
very
me?
serious. Now that you say
Yes.
my students are watching.
Yes, they are
I mean,
listening.
they know I'm not a mediocre
So,
lecturer.
no, I didn't say that.
Professor
I
Hart
didn't
said
say
that
I didn't say that.
Constitution and human rights document, they are written in open textual form. That means that the implementers of the Constitution, it's like a skeleton. So sometimes you need to put meat somewhere for it to work. So now, I've just told you, if you say the president is merely a conveyor belt, if I send a petition today that I believe the Chief Justice have done something wrong, he took Fufu yesterday instead of Banco. Is it just a conveyor belt to send it? If that is so, Ghanaians listen, send a little petition to President John Mahama. He must send them as a conveyor belt.
Okay.
When
He
you
need
read
to read
146,
somewhere.
when you read
Some
Article
discretion.
146,
Yes.
did he mention any president, any role the president plays in there?
Yeah.
Apart from saying that
Okay.
he shall refer.
Okay.
Even
He
he
shall
has
refer.
moved from a
So
conveyor
let me
belt
do
to a
this.
robot.
Let me do this
That's what
briefly. Let me do this
Okay.
briefly,
How you
please. Let me
getting
do this
it?
briefly.